right. Thanks everyone for being here. This is the second seminar of the training term of the Oxford Jurisprudence Discussion Group. And this is a book symposium on Scott Hershovitz, Law as a Moral Practice. And first of all, of course, we want to thank Scott Hershovitz for coming all the way to Oxford to talk about his important book. Of course, he's Thomas and Mabel Long Professor of Law at the University of Michigan. And we've got with us three Oxford people to act as commentators. This is Scott versus
But who's tried to hold you on
So I'm going to present them in the order they're speaking. Stephanie Barclay first. She's a professor of law at Notre Dame, and starting this summer, a professor of law at Georgetown. She's also a graduate student here at Balliol College. I just realized every speaker on the table today has some connection to Balliol College. It speaks for the importance of that college and the development of jurisprudence. Then David Enoch, he's a professor of the philosophy of law at Balliol College and also law philosophy professor at Hebrew University. And lastly, Hassan Dinger, he's associate professor of law and fellow of Balliol College. Scott Hershovitz also he did his DPhil here at Oxford at Balliol College, and can't help but notice that today is the second anniversary of Joseph Raz's passing, who was Scott Hershovitz's first supervisor and mentor, I take it. He passed away on May 2nd of 2022. So again, thank you, Scott, and thanks Stephanie and David and Hassan for doing this. So Stephanie will speak first, and then the other two commentators, and then Scott will comment, and then we'll open it up for Q&A. Okay? Thank you, Stephanie. Please, the floor is yours.
Thanks for that introduction. Thanks so much for being here, Scott. It was a treat to read the book, even before I knew that I was going to be doing this. And I just wanted to say how much I enjoyed the framing with Hank and how illuminating that was. I felt like in honor of Hank, I should bring another budding legal philosopher who likes to challenge my authority. So my son is here, he's 10, and also doesn't like eating his vegetables. But
offended by that, I think.
So to start out with, I want to reflect a little bit on what I take to be the claim that you're making in the book. And I'll acknowledge that I'm newer to this space, and so some of the things I'm going to pose are questions I'd be interested in your thoughts on. At one point in the book, you talk about, on page 18, you talk about ways in which the law is a tool for adjusting our moral relationships with others. Elsewhere in the book, you talk about how, page 103 is one example, the law is aiming at adjusting what we owe to each other. And those things might be different. It might be that if we're thinking more about the second version of the claim that you're focusing on, and sometimes the book hints at this, the goal or purposes of the sources of law or the authors of law. In which case, I think that's just an interesting empirical claim and more controversial. I'm not sure that it's fully backed up, the idea that that's the goal of those who are engaged in the act of law, is to adjust moral relationships. If the first one is the claim, or it just means that we're going to assume that that is the aim anytime that the law is in fact adjusting moral relationships, or just focus on the law as a tool for doing that, that strikes me as very plausible, widely accepted, but maybe true of a lot of other things other than just law, including your fun mobster example that you include in the book, of course, promises. Teachers at school are adjusting moral obligations. Companies, public utilities can adjust our obligations, how much we owe them. And so I think there's a question I had in my mind, if that's really the claim, that is primarily this tool that can adjust moral relationships. What are you telling us that's unique or interesting about the law, other than maybe just volume? The law is doing it a lot more frequently with a lot more people in a lot more context. Are there important differences there that make a lawyer some sort of a legal or a moral expert in argumentation as opposed to the public utility company or a teacher? Elsewhere, the claim, you shed a little bit more light on and the fact that there's no guarantee that the law will in fact adjust legal practices. That's what it's aiming at. Sometimes it doesn't make a difference. This is on page 137. But you talk about when the law does make some of these differences, then we recognize and respond to what morality requires. And morality requires us to recognize and respond to the difference that those legal practices have made. This is an area where I had some puzzles I'd be interested in your thoughts about, but how we decide when in fact the law has been successful in making those moral adjustments. And also, I'd be interested in you shedding a little bit more light on when you find those adjustments morally desirable and when they're not. You point out in the book, in the Charlottesville example, this is the example of freedom of speech protesters in Virginia who a lot of people would agree had the right to engage in protests, some of which that were really racially charged. And you argue that even if they have a moral right, maybe they morally ought not to exercise it. And there were times in the book that I felt myself trying to figure out a little bit more what the criteria was that you were really using to decide when these changes were morally desirable, when they weren't. There were sometimes in the law or in the book, you talked about how, quote, when legal claims are moral claims, there's no gap between the judgment that someone is legally obligated to do a thing and the judgment that she is morally obligated to do it. The moral inquiry is internal to the legal judgment, not something that comes after that. So this sort of statement makes it seem like they're just one and the same. If the law is telling us to do it, then morally, we know that there's a requirement to do that. There's not a gap here. Elsewhere in the book, though, language that is not necessarily inconsistent, but made me wonder if there was at least some other type of gap. On page 20, you talked about ways in which the fact that the law prohibits an act does not so much affect whether the act is wrong, if it has any effect at all, or at least it does not do so directly. And so I was wrestling with, well, if the law isn't actually telling us whether that's wrong or not, doesn't that suggest that there's some gap between what morality is telling us about wrongfulness or not? You also, on page 127, spoke about ways in which there might be acts that are not wrong, regardless of what the state has to say about them. And yet the state still has standing to punish for those laws, even if the law is not morally problematic, which at least suggests some sort of prima facie gap between morality and legality that I was interested in. So what is it that is the, I'll call it like a higher moral criteria, that might not be the best phrase to use, that you're engaging in to evaluate whether or not the law does sometimes successfully create moral obligations? I know that you sometimes say that that's not the most important question. I think that's fair. I think you drew a lot of great attention to unhelpfulness of some of the labels in these debates and fixation on some of these questions. But nevertheless, I did find myself wondering, what is that moral criteria we should use? Early on, you obviously incorporate Scanlon's, what we owe to each other. But then you don't spend a ton of time in the book talking about Scanlon's view of what anyone would rationally have to or reasonably have to agree with. There's obviously a lot of things about the law. I love the donkey in the bathtub example that people wouldn't reasonably agree with. And you contrasted a lot of the bad answers on page 118, consequentialism, other instrumental reasons. But then when you were talking about the differences between Lincoln, who ignored some of the legal requirements like habeas, or Roy Moore, who also ignored some court orders, there was an interesting sort of tension between when you are morally justified and maybe even obligated to ignore the law. I'm setting aside Nazi regimes because they're such an overused example, and I liked the Lincoln and Roy Moore contrast, versus when you should go along with the law anyway. And I want to just highlight a little bit of complexity with one other example you used about segregation. So on page 108, you talked about here that these segregation laws in the South, they're just clearly not laws that are able to claim any sort of authority, or that they have successfully changed these moral obligations for a few reasons. You say they didn't solve coordination problems, they're not helping us discharge collective responsibilities, they're maybe nominally democratic. So let me just push back on this for a minute. first caveating that I obviously agree with you that the segregation laws are immoral and problematic. But one could certainly argue that the Fugitive Slave Act was solving a really important collective action problem. States had different ways of handling what do we do if there's a free slave that has been caught. We have to pick one method for handling that problem. That sounds like coordination to me. There were certainly arguments that were made by slaveholders at the time that slavery did help them discharge collective responsibilities of agriculture that were valuable for the entire country. So I felt like you moved a little too fast past some of those justifications, I think wrongly, but that those at the time were using to justify some of these laws. And so what other moral principle is there one that you would point to in terms of why these laws aren't successfully able to claim authority or any sort of moral obligation over us? To move, quite a ways the other direction where we lower the stakes, I thought the stop sign example was great, and you're right, often frequently used in these contexts. What you pointed out, to whom do we owe the obligation to stop at a stop sign, even if we think that we can see nobody is there, no one has a risk of being hit, it's a clear day, you can see for miles, stopping seems unnecessary. And you pointed out it might be that we're misjudging, and that's why under Raz's approach with an exclusionary reason, we should just discount our own judgment. But this goes back to some of the earlier questions I was asking. If we just assume that your obligation is to the state and no one else, that alone can be a relationship. That again is true of relationships you might have with your school, with utility company, with the head mobster. So what is it? What is it that's different about the law in a context like that versus other potential tools that are changing moral obligations? And with that, I'll go ahead and pause there.
Thank you very much, Stephanie. David.
Thank you. I'm going to go for longer. And
I'm glad.
There's a handout that may help in following. There's more stuff on the handout that I'll go through, even though I will be going. So this is a fun book, and if you know my relationship with jurisprudence, you know that it says a lot if I find it fun, even though it's in jurisprudence. And there's a lot of stuff that I agree with here. I'll say a few things. First, although there'll be more here that I disagree with, I should start though with how daring the book is, and especially how daring Scott is in coming to an event in the UK, having written a book in which he explicitly says, and I'm not kidding you about that spending time playing baseball is much better than playing football, which he calls soccer for some reason. So at least I hope that I'm among a friendly audience on this. Anyway, here are some of the things that I think are important in the book and that I agree with, despite some of the disagreements that will surface later on. So Scott says at some point that the book is as much about morality as about law, and I agree with almost everything he says about morality. In particular, he emphasizes that moral reality is not constant either. We change it all the time with our normative powers, and I think he's right about that, at least to an extent. We change the moral landscape, and I agree that this makes it the case that sometimes people may have rights even though they ought not to have them, or at least even though it ought to be the case that they don't have them, and vice versa, and that I think is important. I also accept, and this is partly for the reason just noted, that there is no problem for a view such as Scott's, for a view of the law such as Scott's, to allow for the possibility of morally pernicious and yet legally valid norms. This is important because apparently, I here take Scott's word for it, in the history of the subject, this has been a major concern motivating positivism. So if you can show how, despite not being a positivist in some senses, we don't care about the terms, and that's okay, he can still accommodate that desideratum. That's obviously a nice advantage of his view. He makes the nice claim that courts answer the question who owes what to whom, rather than questions such as who ought to owe what to whom. And this allows him some leeway to say that it shows that Scott's view can retain the distinction between what the law says and what it should say. Yet another desideratum on which legal positivists may have been thought to have a clear advantage. Scott emphasizes how flexible our talk about law is. That there's absolutely no justification to assume that when we talk about, say, what is and is not legally valid, we always mean one and the same thing. He's right about this. This will be important in what follows. Although I should say here, echoing a little bit something that Stephanie said, I don't think this is unique to law. This is just a general point about how we use natural language. But its derivative with regard to law is going to be significant. It's significant in Scott's book, and it will also be significant in my comments. I actually like the thought that criminal law often makes a normative difference not by changing the moral status of the prohibited action, but in changing the moral status of the intervention by the state or the punishing by the state. Though I hadn't thought of the problem that Stephanie raised to this. I'll be interested in hearing what you have to say about that. Okay, but that's it for being nice. Here are some critical points. The first one, that's number 2 on the handout, really does follow up on Stephanie. And partly it's a request for more details. What does it mean to say that the law is a moral practice? One would have thought that this is a legitimate question, given the title of the book. But it's also the beginning of an objection, because the worry is that Scott gets a lot of mileage precisely because he's not being sufficiently clear and doesn't distinguish different claims that may be meant by this. So I put on the handout some of the things that Scott says. I should say, I see that everyone here is very old-fashioned. I read the Kindle version, and I'm not sure I got the pages right. It may be like one page off where I read it. So, but here are some of the things that Scott says. Again, Stephanie mentioned some of them. The central idea of this book is that law is a moral practice, a practice that aims at creating, extinguishing, enforcing, etc., our moral rights and responsibilities, and that court is a place we go to resolve conflicts about them. Or legal practices are tools for adjusting our moral relationships. He often speaks about the law, but and also about his favorite example of promising as something whose point it is to shape moral relations, or rights and responsibilities. We employ legal practices in an effort to adjust who owes what to whom. Law is a moral practice in that it aims to adjust our moral relationships. So I just need to know what aiming, what the point, what being a tool for means. If the claim is just that this is how sometimes, even often, law is used, then Scott gets his main thesis for free at the price of being a very weak thesis, and as Stephanie noted, also one that applies much, much more generally. If the point is that this is how law is always used, as a matter of necessity, then the claim is not too weak, but it is ridiculously strong. There is no way in hell it's true. The point may be different. It may be about the aim of some agents, the intentions of some agents. I'm not sure this is a good idea in general to pursue this, but even if you're into that kind of stuff, I think that Scott owes us at the very least quantifiers and maybe also modal operators. Is it that always and necessarily always used with these intentions? Again, way too strong to be plausible. Is it just that sometimes some agents use the law with that intention? Sure, not very informative. Something else, perhaps, I'm not sure, but then we need to know what that something else is. Perhaps it's just that in an important privileged subset of cases, the agents have that intention. It sounds like it's potentially interesting, but I'd like to know more about this subset. So I really do think that at this point, we don't have enough details to even assess for truth value the main thesis of the book. So much for number 2 on the hand. Proceeding to, don't be alarmed. As I said, I won't go through everything. We'll be okay. So I'm not more. So this is number 3 now. I'm not more interested than Scott is in finding the right drawer to in the jurisprudential cabinet for Scott's view, right? And I am really not invested in these terms. But what is important is that Scott thinks that legal rights are moral rights. That legal arguments are moral arguments. That what we, I guess all of us necessarily, I'm not sure, do in court is to conduct moral discussions, that law is a part of morality. And he also thinks that this view is at least somewhat supported by appreciating the fact that the law is a moral practice. Though in some points in the book, he's very explicit about these not being the same, and at others, he does seem to slip in between the former follows from the latter. So partly in order to evaluate this, we need to have the details that I'm sure we'll hear shortly about what it is for the law to be a moral practice. But let's talk about the general claims here. And here, I'm not going to talk about I'm only going to talk about the killing by disambiguation. So I have a completely conclusive argument against anything in the vicinity of Scott's view. Here, it ends with a QED, so it must be conclusive, right? Here's the argument. There's no contradiction in saying that the law requires that you file, but that you have no duty to file. Think about it for a second. I say, look, the law requires that you do so and so, but you have no duty to do it. Have I contradicted myself? The answer is clearly no. And that, as far as I can say, is the end of the story. The rest of the debate, it seems to me, requires sociological analysis, not philosophical. But Scott has an answer. Now, he doesn't state this objection explicitly, unfortunately, but I hope that the following reconstruction is a loyal reconstruction of what Scott would say to you. So Scott distinguishes between the very different things we may mean when we talk about a community's laws. Remember the flexibility of the term, and I have some of them on the handout. The norms that are expressed in legal text, the norms that are accepted by legal officials, the norms that are enforced by officials, the norms that are followed by lay people, and something more complicated, a la Hart, and this is what the norms that are authoritative, by which he means the norms, the norms that are genuine norms, that are genuinely reason-given, for which it is an analytical truth that they are reason-given, something along these lines. The norms such that it's necessary true that we have genuine reasons to follow. And if I understand Scott correctly, he accuses positivists of ignoring this last use. So positivists are obviously correct, indeed trivially correct, about all of the previous ones. The laws that are accepted here, sure, that's not a part of morality, that's a part of sociology. Similarly for others. But positivists just ignore the last one, the sense in which when we talk about the laws of the community, we talk about the norms that are authoritative, that are genuinely normative. So when I say there's no contradiction in saying that the law requires that you file, but that you have no duty to file, Scott can say, well, sure, in any of these other uses, all of them except for the last, there is no contradiction, and I can accommodate that. But there is a contradiction with the last use. I think that's what he has to insist. There are many good things about this line of thought. Do you see why I call it killing by by disambiguation? This should be clear at this point. The killing should be clear. Thank you. And there's something nice about it. There's almost like, it's a peace-loving thing. There was this philosophical quarrel. We have now distinguished different senses of the question, and now we can all really happily agree that once disambiguated in this way, we get this result. Once disambiguated in this other way, we get this other result, and that can be good. But it can also be bad. So here are some examples from different. So some of you may know the dispute between people who are objectivists and people who are subjectivists about ought. It's like a big philosophical quarrel, but here's one way to go. Wait, sometimes when we say ought, we mean the objective ought. Sometimes when we say ought, we mean the subjective ought. And maybe we should just disambiguate. And in that case, it actually seems to me like a good way to go. Then there are other cases where it seems to me clearly a bad way to go. Shall we just distinguish between what you utilitarianly ought to do and what you Kantianly ought to do, and pretend that we have brought peace to moral philosophy? No, there's a serious argument there, right? So there you don't want to kill the dispute by disambiguation. So now the question is, what should we say of our case? There are, I should also say, borderline cases. So in discussions of free will, sometimes people today distinguish between libertarian free will and compatibilist free will. And I'm not sure they're right. I think that that's closer to the Kantian utilitarian case rather than to the, but reasonable people may differ. So what can we say about our case? Well, the first thing I want to say is that if Scott is right and positivists have been silly to ignore this last use, and what they say is trivially true of all the others, then people who reject positivism have been just as silly in the opposite direction. Because what they say is obviously true of the last use, and it's obviously false of the rest. Right? So everyone is equally silly. Indeed, one may conclude that the discussion has been silly and we should stop wasting our time on it. I'm not shocked, but maybe some of you are. There are other things that can be said here. Another thing that can be said is to insist that despite disambiguation, there is still a sense that is privileged. So you could mean all these different ones, but there's an important sense in which one of them gets priority. This is what I think about free will, right? So you can talk about libertarian free will, you can talk about competitive free will. Sometimes we're interested in this, sometimes, but there is some sense in which one of them is the one that we aim for. So I think this is something that Scott would have to say here. There are hints at him saying that about the last one, but I would say, well, first I would need to tackle what he says about discussions in court, which I'm not going to do now because I don't have the time. But I also, when it comes to which sense is privileged, I remobilize my Q in the argument. Because in the sense that we care about, there is clearly no contradiction in saying that the law requires that you fight, but that you have no duty to fight. QED. Okay, I'm going to skip the disagreement in courts part. I'm going to skip the simplicity part, and I just want to use like 2 more minutes for number 4 on my handout. In chapter 7, Scott draws conclusions about how we should train lawyers. We should teach them that they're taking part in a moral practice, and this will make them less holy. And also about what lawyers owe their clients. So they owe them a lot, but less than many of them think. In particular, we ought to stop teaching lawyers that their clients' interest trumps all else. That's a quote. But I don't think this is how one establishes such conclusions. These claims involve empirical hypotheses about what kind of effects in the world, about how holy lawyers will be, given different ways in which we teach them law. So, you may need to leave the armchair and to do the work for those. Also, I just find the hypothesis that the way forward with professional ethics is making people realize that positivism is false. I find this, it's not just obviously an empirical hypothesis. It's an obviously false empirical hypothesis. I know you can run the experiments if you want, but I know what the result will be. The needle won't move even a tiny little bit. Here's a nice sentence from 166, or thereabouts. We ought to invite lawyers to see law as a moral practice, to see themselves as part of a moral endeavor. This also includes the ambiguity about what it is said that the law is a moral practice, because the 2 parts of that sentence are really importantly different. Of course, we should teach lawyers that they are part of a moral endeavor. We should teach them something about what the law does to people, for instance, and how they can be or refuse to be a part of that. I'm all on board with that. But the thought that the way to do that is to teach them jurisprudence just seems to me to be empirically entirely impossible. All right, I'm going to stop there. Thank you.
Thank you, David. Commentators, now Scott has the floor.
Well, thanks to the commentators, especially thanks to all of you for being here. Thanks especially to the organizers for putting together the opportunity. I'm going to ask a question stipulated in advance that no one should be embarrassed about answering it honestly, but I'm curious because it will structure the way I'll approach responding. How many people here have read the book? Okay, so a handful, because I always think these events are weird introductions to the book, because now you've heard a laundry list of problems, right, or at least purported problems, without maybe having any idea what the thesis is or what it's about. And so I think there's a marker here, and I'm just gonna start not by replying, but by trying to say something about what I'm up to in the book, which maybe then will make it easier to say something about this challenging set of responses to it. So there's a kind of picture that I think is lurking in the background of certainly lots of conversation among philosophers of law. I often think plausibly lurking in the background of lots of the things that lawyers might say about law or have in mind as they're engaging in legal practice. Maybe even possibly, I don't know, like lurking in the background of some thoughts that lay people have about law. It's a picture that you might represent. Hang on, that shouldn't be an S. I don't know why. It's a picture that you might represent this way. You might represent with an M and an L. And so what are you up to here? Well, like the thought is like there's two normative systems, at least two. There's like a moral normative system and there's a legal normative system, and they're not the same thing. Sometimes this is called the two-system view. I think that's kind of a misleading way to think about it for like a reason that was alluded to in David's remarks, because like you might think, oh, there's lots of other normative systems floating around, like the rules of Oxford or the rules of University College or the rules of football or the rules of baseball, and on and on and on. So it might be that instead of a two-system picture, we should have like a many system kind of picture, and maybe people do, but for our purposes, we're thinking at least about these two possible normative systems. And if you've got that picture in mind, right, then there's lots of questions you could ask about the legal normative system, right? One question you could ask is you could be like, hey, what's in that? What's that stuff, right? And part of what's been going on in jurisprudence for a very long time is people arguing about what's in there. So Austin, right, says, what's in here are the commands of a sovereign. And then along comes Hart, and he says, no, you can't make sense of this like phenomenon just if the only conceptual resources you have are commands, right? And argues that actually what's in here are rules, and not just any set of rules, but a kind of richly structured set of rules. Primary and secondary rules related to each other in a certain kind of way. In an early intervention, Dworkin shows up and he says, not just rules, but also principles, right? And then, Scott Shapiro comes along much later and he says, not rules or principles, it's plans. So like that's a kind of jurisprudential conversation. What's the stuff that's in there, right? Here's another kind of question, right? You can ask. You can say like, oh, look, it seems unlikely that this circle here, this legal normative system, that's like a naturally occurring feature of the world that we find independently of our own practices. Like, what is it in the world that brings this into being? And then what determines what its content is, right? Like, that's a kind of thing that philosophers of law had a conversation about for a very long time, right? Like, presumably it's some of our social practices. Which social practices are it that are necessary? Like, are it that constitute a legal system, right? You can notice, like, flipping around, you can ask a kind of set of parallel questions about this moral normative system. You could wonder both what's in there, and you could wonder whether it's a naturally occurring feature in the world or brought into being by some of our activities. Like, those are the kinds of questions at issue in metaethics, and the kind of parallels here, right, are part of what leading Scott Shapiro and David Plunkett to say, oh, maybe these are like parallel bits of some broader field, metanormative theory, right? You can also then start asking questions about the relationship between, right, these circles. You might wonder, does the stuff that's in M have any influence or play any role on determining what's in L, right? And this is the debate that we tend to think about when we talk about positivists and anti-positivists, right? The positivists tell us that no, right? The stuff that's in morality is not playing a role in determining what the content of the law is, right? It's just fully determined by the social practices that are bringing law into being, right? And then you've got the anti-positivists saying, no, morality plays a part in determining what the content of the law is. You can also ask questions about the impact in the reverse way, right? You can ask, well, does the law have any impact on what our moral rights and responsibilities are, right? And we tend to think of that as a question about our obligation to obey the law, right? Maybe also obligations to resist or inform the law, right? So this picture, right, has been the organizing picture, I think, for lots of jurisprudential conversations. And there's good reasons for that. I think there are things that are attractive about this picture. And I try to say up front in the book what some of them are, but the book is written as an invitation to entertain a different possibility, right? To entertain the possibility that it's all along a mistake to start from the premise that there are two separate normative systems here, right? Rather, right, we might think that we've just got one normative system. We've just got morality, right, which tells us what our genuine rights and responsibilities are. And then we might notice, right, that we've got in our lives lots of practices that are plausibly understood as ways of adjusting morality, right? So promising is the primary example that I use in the book, right? Plausibly understood as a practice that people engage in part, as Hassan says, not just, in part to rearrange their moral relationships, to take on an obligation, to give somebody else a right. That seems to be like a big part of what promising is about, right? Other practices, right? Stephanie mentioned some as part of this challenge of like, are you saying anything distinctive here? Because there's all sorts of situations in which we make rules for each other, right? Like in a university, right? Rules for our children, right? We also, right? Like make claims on one another. We forgive each other, right? Like we could go on with like lots of bits of our lives that seem to be not just, but partly, maybe even in some sense, predominantly about adjusting morality. And then the suggestion in the book is, well, wait a minute, what if we understood law that way? What if we saw it as something that was integrated into our moral lives rather than an attempt to bring into being a separate normative system? And the assertion in the book is this turns out to be a highly illuminating way to think about law, right? It's illuminating in various respects, right? It's going to help us make sense of the significance that we accord our legal practices, right? It's going to help us make sense, I think, of some of the conflicts that we have about our legal practices. It's going to help us understand, I think, importantly, morality a little bit better than we do. I think in legal conversations, there's often a kind of, not in legal conversations, in philosopher of law conversations, there's often a kind of cartoon picture of morality, and we fail to notice how rich many moral phenomena are. So I think it's going to help us understand not just the legal bit of our lives better, but understand the moral bit of our lives better, and and here's what I want to emphasize, because it's going to give me a kind of window into responding to some of these thoughts. It really is written as a kind of invitation. Like, hey, I'd like you to like try this view out and see whether it delivers on this promise, if it helps you understand things, right, better than you might have. All right, now let me like shift from offering that overall picture to then saying something about like a few of the many rich and important challenges that were offered just before. There's always like a challenge in these events. People are like, we will invite folks, right, to criticize you for 45 minutes, and then could you say something in 10 minutes, which actually is like the right balance of time for the way these events go. But what it means is I'm just going to try and organize themes and reply to what I take some of the main challenges to be, and if I've got that wrong, right, if there are like bits that you want to press further on that I have not responded to, then absolutely let's do that in the question and answer session. So all three commentators are pushing in the same place, which I actually think is like a really great place to push. So what do they have in common? They all want more or better on the question, just what do you mean when you say that law is a moral practice, right? Like what's the nature of that claim? What's the evidentiary base for that claim is something that that all three people are pressing on. I want to endorse Hassan's generous reading of the presentation, which is to say, like, I do mean to say the sort of conjunctive thing that Hassan is saying. How did Hassan put it? That legal practices are are tools. Oh, there it is. Legal practice at the top of the handout. Legal practices are tools for adjusting on more. Oh, I said this. It wasn't just a sign. Though that's good.
Two votes.
Yeah. Legal practices are tools for adjusting on more relationships, and they're typically employed for the purposes of doing so. Right. And I have both thoughts, and both thoughts are key to the claim. And then David comes in, he's like, I'd like to know more about typical, right? Could you give me a kind of quantifier? Could you tell me about whether this is a claim about the particular mental states of the people involved? Is it a claim about their intentions? And I'm going to resist giving you a quantifier. I want to say something in general about like the demand for a quantifier, and then I want to like put it in context of the overall argument of the book. So there is a stage, if you look hard enough at lots of jurisprudential theories, there's a stage where they all face a similar kind of problem, right? So Hart says to you, for instance, that that like a legal system, every legal system has a rule of recognition. A rule of recognition is constituted by a kind of convergent practice. Right? He very quickly notices, right, that the convergence may not be total, and then he resists providing a quantifier for you. How much, he waves the question off. I think there may be reasons, maybe we could think about them later on, that like these claims are fuzzy. But I want to, having noted that lots of jurisprudential views are embarrassed by a similar sort of challenge, I want to say two things about it. One is that's part of why the argumentative strategy of the book is the way it is, which is to say, I'm offering you an invitation to try out a certain way of looking at these institutions, at these practices, right, to see them as things that are integrated in our moral lives rather than things that are separate, and then to ask, right, at the end, right, which I ask explicitly in the book, having gotten to the end of this, right, do you see reasons to look at it another way? Reasons that, like, can't be accounted for within the picture that I've given you, right? And so partly, right, the argumentative strategy is not to say, to do what David wants me to do, right? Which is to say that I'm going to investigate the world empirically, right? Partly because I'm not yet sure what I'd be looking for, right? But rather, I'm going to suggest that you'll in the same way. Let me give you a further. So suppose I make the claim, as I made earlier, that like you really wouldn't grasp what promises were unless you understood that they were a moral practice. They were a tool for adjusting people's moral relationships and typically intended for doing so. Are they always intended to do so? No. Sometimes people promise insincerely, right? Are they always well understood by people that this is what they're doing? No, many people who are perfectly competent to make a promise are inarticulate about what it is that they're doing. So why would you make this claim about them? And I suppose I'd say something like this, right? This claim is the best explanation of their behavior, in part because they're nearby many things that they could do in the ballpark of making a promise that are not making a promise, that would serve other aims that we might plausibly attribute to them, like raising expectations about what their behavior will be, or providing some kind of prediction about how it is that they'll behave in the future, and so on. And all of us know, right, even if we're not articulate about it, all of us know, right, most of us know how we can carefully do one thing and not the other, right? And this shows up when people say things like, oh, like I'm going to the party, but don't hold me to that. Right, that's different than I'm going to the party. You can count on it. And so you might ask, oh, like, what's the point of saying the second thing rather than the first thing? Or what's the point in saying the second thing rather than just I'm going to the party, just flatly, right? And like, I think plausibly, right, the thing that makes sense of it is, right, the you can count on it is best understood as a way of adjusting people's moral relationships. That's why people might say this thing, even if, right, they're not fully articulate themselves about why that is. Similarly, I want to say something about our legal practices. They'd be very hard to make sense of, I think, apart from the supposition, right, that we are capable through these sorts of activities of changing genuine rights and responsibilities. And I think that is, like there's lots of other things that you could do, right? In the ballpark of regulating people's behavior, controlling people's behavior. Why do it through legislation, adjudication, regulation, through the sorts of practices that we have? I think it's very difficult to make sense of, apart from the supposition that we can bring it about through these activities, that people do have genuine rights and responsibilities sometimes to behave in accordance with the norms that these activities purport to make binding on them. But I just want to, like, again, assert the overall argumentative strategy. Try out this way of looking, right? Take people to be acting this way and see if you think it makes sense of the kinds of things that we observe in the practice. All right, so the second thing I want to make sure I address, I'm cognizant of the time. So the second thing I want to make sure I address is, like, only David purports to offer, right, a knockdown argument, right? He says, and let's get David's wording. He says, the law requires that you fie, but you have no duty to fie. He says this is obviously true. This obviously can be true. It's not a contradiction, so QED, Scott is wrong. Now, as David discerns, I have a way of accounting, right, for the sentence that he's offering, right? Because I think there's many senses in which it could be true that the law requires you to do something, right, but that you're not under a duty to do it. Right, and let me just offer you an analogy. I might say, my parents are requiring me to go to the party, right, even though I don't have an obligation to do so, right? What might I mean? I might mean that my parents are insisting, maybe vociferously. I might mean, right, just that they're expressing the view that I must. I might, depending on the context, mean something more robust than that. I might be that they're, like, threatening me. Right. This is a sense in which I can be required to do something, right, that I think is, like, just part of ordinary English usage, that if I fail to do it, then I'll suffer consequences. Right. And similarly, I think you can make perfect sense out of the thought that the law is requiring me to do this, as legal institutions are insisting of me, maybe even penalizing me, right, in the event that I don't, but I'm not under a duty to do it. David says I'm trying to kill this by disambiguation. I think I'm just trying to make sense of it, right, by disambiguation.
Yeah, that's what I said.
What's that?
That's what I said.
Yeah. But David thinks that there's something else going on. That there's, like, some core sense in which, and I should say I'm puzzled by David's use of the word requires here. And actually, it strikes me as an interesting word choice, because if David had done something a little different, if he had said, consider the law obligates you to fie, but you have no duty to fie, right? That sounds weird, right? The law obligates you to fie, but you have no duty to fie. You would wonder,
So
but
weird is in contradictory.
What's that? It sounds contradictory.
Not to mine.
Not to your ears. How about you have a legal duty to fie, but no duty to fie? Okay, good. Well, so it sounds like something that might be true to David, only because I assume he's going to go on to tell us a story about what work legal is doing there. You would owe us some story. If I say you have a legal let me give you another analogy. If I said to you, I have a family obligation to go to the wedding, but no obligation to go, right? It's raising a question about how, like, what work is the word family doing in that sentence?
Say I have a purported obligation to go, but no obligation to go.
What's that? Say it again.
I have a purported obligation to go, but no obligation to go.
Oh, wait, are you killing by disambiguating?
No, I'm just saying that legal obviously linguistically functions like purported does, and not like family does.
Okay, good. So I don't think that's obvious, right? Which is to say,
Shall we vote?
what's that? Well,
No, I'm not kidding. Actually, this is
No.
a point about natural language. Clearly, how people use language is relevant, and then we should worry about other natural languages.
Well,
This is what the discussion is about.
So here's what I think one wants to say. What I want to say about this is sometimes the word legal functions like purported, and sometimes it functions like family. Yeah, and I don't think I think that Well, you're committed to the assertion that it never functions. Well, are you committed to the assertion that it never functions like family?
I'm not in the business of legislating for people how to use natural
Yeah.
language. You can use the words as you want.
Yeah, but I don't think you can take the view, right, that it never functions as the word family.
I think that in the sense that we care about, to the extent that we care about, it clearly functions like purported. If you choose to use it, if you show me that some people use it in this other way too, I'm happy to disambiguate.
Yeah.
But then, as I think I said, maybe I didn't say it in my presentation, there are really only two ways to go. Either killing by disambiguation, the whole topic is silly, let's stop wasting
Yeah.
time. Or there is some privileged sense. But then clearly there is no contradiction where I say there isn't. And so
Okay, good.
the privileged sense is that one.
So let me just try and capture what I think is the dispute between David and I. We've at least gotten to agreement about this, right? Which is to say, these words are used in lots of different senses, right? And David thinks that look, Hershovitz is like disentangled senses, and now we're at the fork of a dilemma. Either it turns out that we've all been silly, right? And we should stop. Or there's something legitimately interesting here. But if there's something legitimately interesting here, David thinks he's obviously right. Yeah. And so what do I think? I think, well, I'm glad that you've agreed the word is being used in lots of these senses. I don't think, right, that people are revealed to have been silly, right, by the noting of the various senses, because I think there's actually reasons, right, deep and important reasons that it's been hard for people to prize them apart. Why? Well, let me give you some of them, right? We engage law in many different ways, right? We care about what these institutions will do to us. We also care about what they're justified in doing to us, right? And so it's not surprising, right, that you might sometimes get slippage, right, between various ways of speaking. It's also true, I said this, like, this book is in large part a book about morality and how complicated morality is. It's also true that morality is such, right, that you will often become obligated to do what you're being told by certain people that you must do. Right. So if morality is attaching great importance to the social stuff, then it will be extraordinarily tempting, right, to think of the law just being the social stuff. Right. But I think it's important, right, to like open up the possibility that that's not true. I think we're probably going to talk about this more. So let me. Well, I'm like. I have so much more to say about all of this, but if I keep talking, then nobody else in the room will get to talk. So I think I should stop, and then we'll see what the questions bring up.